Hi, I'm Verlan Kwan, a partner in Keystone Law Group, a probate firm in Los Angeles. Today, I will be going over what an executor can and cannot do. Let's get started. During estate administration, it is not uncommon for conflicts to arise between the executor and estate beneficiaries, leading beneficiaries to question whether the executor is entitled to override them. The first thing to understand about executors is that they are fiduciaries. They are obligated to act in good faith and solely represent the beneficiary's best interest. Beneficiaries often falsely assume the executor's lawyer represents their interests as well. Even though the executor is responsible for acting in the best interest of the estate, the executor's lawyer generally does not have an attorney-client relationship with the beneficiaries and cannot be counted to advocate on their behalf. If beneficiaries suspect the executor has breached their fiduciary duty, they will need to find their own probate lawyer to bring a claim. While beneficiaries can feel frustrated by the executor making decisions without consulting them, executors do have the right to make unilateral decisions. The scope of their power depends on the provisions of the will and whether the court has granted them limited or full authority. Most often, an executor's level of authority comes into play when selling estate property. With limited authority, an executor can sell personal property without the prior consent of the beneficiaries, but they will need to obtain court approval prior to selling real property belonging to the estate. With full authority, an executor can sell the decedent's personal and real property without prior court approval. However, in order to sell estate real property, they will still need to notify beneficiaries in writing by serving what is known as a notice of proposed action. Now, let's cover a few of the things executors cannot do. While an executor cannot change or withhold a beneficiary's inheritance arbitrarily, executors must satisfy the decedent's debts prior to making distributions to beneficiaries, or at minimum holding back sufficient reserves to pay debts and other expenses of administration. So if the estate does not have the funds to fulfill these debt obligations and also distribute specific gifts set forth in the decedent's will, beneficiaries' inheritance may be reduced. Next, executors also do not have the power to remove a beneficiary from a will. A common question we get from beneficiaries is whether an executor can unilaterally remove a person as a beneficiary from an estate. The short answer is no. While executors may threaten beneficiaries with removal to intimidate them, they are not entitled to take such action. Which brings us to our next point. The executor cannot stray from the terms of the will. Executors are bound to the terms of the will and open themselves up to liabilities if they stray even a little. Executors who are not adhering to the terms of a will risk suspension, removal, and surcharge. Likewise, if the will contains ambiguities, executors cannot take it upon themselves to interpret them. Sometimes, a decedent's will may be imperfectly drafted and may contain ambiguities. The appropriate course of action when there are ambiguities is to file what is known as a petition for instructions with the court to obtain clarification about the true meaning of the will's terms. If an executor simply tries to interpret the will on their own, they can be held liable for any missteps if the will was later determined to be interpreted incorrectly. Next, let's go over a couple of gray areas, such as whether the executor can sue a beneficiary. If the executor suspects a beneficiary to have engaged in misconduct that negatively impacted the estate, such as unduly influencing the decedent to change their will or stealing their assets, the executor is entitled to sue the beneficiary. In such a scenario, the executor may be entitled to seek damages and reimbursement of attorney's fees and costs as well. The last gray area has to do with evictions. Executors generally are permitted to evict beneficiaries if they are not the sole beneficiary of the property. Executors are almost always permitted to initiate eviction proceedings if a beneficiary is residing in estate property without having a valid lease agreement. Particularly when multiple beneficiaries are inheriting the property, it typically needs to be sold so the beneficiaries can receive their inheritances in cash, unless, of course, all the beneficiaries agree to keep the property. This concludes Keystone's video on what an executor can and cannot do. Learn how our lawyers can help you by clicking on the link in the caption to schedule your free consultation. Also, be sure to subscribe to our channel to be notified when new content has been posted. Thanks for tuning in.